Hey everyone, welcome to This Explainer. If you're the kind of focused learner who loves untangling complex systems, well, you're definitely in the right place today. We're going to be looking at this absolutely fascinating, high-stakes legal jigsaw puzzle. Basically, we're exploring what actually happens when the unstoppable force of artificial intelligence meets the immovable structure of the Indian judicial system. It's this massive collision of cutting-edge innovation and rigid regulation, and we're going to break down the exact rules being proposed to keep this whole thing from going off the rails.
So just imagine this for a second. Imagine your highly personal information, right? Your financial records, your location data, your private disputes, suddenly becoming judicial data that gets fed into some massive machine learning algorithm. Kind of scary, right? How exactly do the courts balance the crazy efficiency of AI with the incredibly strict privacy laws that are supposed to protect your identity? Well, it's a monumental challenge, and the Supreme Court's suggested AI regulations are basically trying to thread that very, very delicate needle.
Okay, so here's our roadmap for navigating this regulatory maze. We're going to start with the AI legal intersection, then move on to defining sensitive judicial data, unpack the rules for court AI systems, explore the data fiduciary dilemma, and finally, look at resolving the legal conflict.
All right, part one, the AI legal intersection and the really tricky dual regulatory burden it creates.
Okay, let's dive into this. When regulators actually sat down to write out the rules for AI usage, specifically in Section 48, they immediately hit a massive roadblock. See, on one hand, you've got the Information Technology Act, or ITA, way back from the year 2000. That act steps in to govern any non-personal data that the AI is churning through. But at the exact same time, you've got the brand new Digital Personal Data Protection Act, the DPDPA, from 2023, and that is the absolute heavyweight rulebook governing personal data. So, right out of the gate, any AI system you deploy in a court doesn't just operate in a vacuum. It has to simultaneously comply with both of these incredibly dense, totally different legislative frameworks. It's a lot.
Moving on to part two, defining sensitive judicial data and how we actually go about protecting identities.
Now, to actually navigate these strict new rules alongside everyday court proceedings, regulators realized they had to literally invent some new terminology. So they came up with sensitive judicial data. This is defined broadly, but still specifically, as any personal identifiable information of the parties involved, the witnesses, or the legal reps. It also loops in any court process info where an unauthorized leak might cause harm. Because think about it, in a courtroom we aren't just talking about your email address getting leaked. Someone's personal liberty is often on the line here, so it absolutely demands a highly specialized layer of protection.
But that begs the question, what exactly counts as harm if an AI system actually fails or leaks data? Well, the regulations define it super clearly when it comes to AI incidents. Harm isn't just some hypothetical minor inconvenience. We're talking physical damage, financial ruin, or severe damage to the reputation or rights of an individual, an institution, or even physical infrastructure. If an AI mismanages this sensitive judicial data, the real-world stakes are honestly just massive.
So let's look at part three, the actual rules for court AI systems, diving into the Chapter 7 guidelines.
To prevent all that harm we just talked about, the Supreme Court laid out some really strict technical guardrails. Step 1. Sensitive judicial data absolutely cannot be transferred to external systems without express written authorization. No exceptions. Step 2. This is the principle of data minimization. Basically, if two different AI systems can do the exact same job, the court is legally required to pick the one that processes less personal data. And Step 3 is anonymization. Whenever it is technically feasible, personal data literally has to be scrubbed and anonymized before it's ever used to train or test an AI.
1 year. Now, this is a really crucial metric to keep in mind. Every single AI system that a court uses doesn't just get a one-time stamp of approval. No way. They are subject to mandatory cybersecurity audits at intervals not exceeding 1 year. And the outcomes of those audits? They have to be permanently recorded in an official AI register. So the courts are forcing these algorithms to maintain a really rigorous, ongoing standard of security.
Which brings us to part 4, the data fiduciary dilemma. Basically, who is left holding the bag if things go wrong?
So despite all those incredible safeguards, there is still this massive regulatory conundrum lurking just beneath the surface. The DPDPA introduces this concept of a significant data fiduciary. Basically, that's any entity that handles sensitive data, which puts them under the absolute highest level of legal scrutiny possible. But, and here is the really crazy loophole, the DPDPA never actually defined what sensitive data is.
It just left this huge, glaring gray area right in the middle of the legislation.
So, the really crucial point here is this. We just learned a minute ago that the judicial regulations specifically labeled their own data as sensitive judicial data, right? Well, because of that, if all the data floating around the judicial system is inherently deemed sensitive, the courts automatically become significant data fiduciaries by default. Just by trying to modernize and use AI to process their files, the courts accidentally inherit this incredibly heavy, restrictive legal burden under the DPDPA just to do their normal daily operations.
Finally, let's hit part 5, resolving the legal conflict and trying to find a realistic way forward. So how in the world do we let courts actually use AI without completely violating the strict data protection laws that they themselves uphold? Well, the DPDPA offers 2 main escape hatches or exemptions. Section 17(1) gives a restricted exemption, but crucially, it leaves courts on the hook for Section 8(5), which means they are still legally liable for maintaining really heavy, reasonable security practices. Honestly, that's just not enough relief for a court to operate freely. However, Section 17(2) offers a complete across-the-board exemption. But to unlock that, courts have to be officially notified as instrumentalities of state, specifically for the purpose of maintaining public order.
Because this legislative overlap is just so intensely complicated, the ultimate recommendation that experts derived from analyzing all this is actually pretty direct. They suggest that the Ministry of Electronics and Information Technology, that's MeitY, needs to step in and officially declare the court systems as completely exempted under Section 17(2). That is the administrative bypass required to avoid all these messy legal conflicts. It's the only way to let the judiciary actually leverage AI without being totally paralyzed by these massive fiduciary liabilities.
All of which leaves us with this really provocative final thought to chew on. To actually make AI work inside the justice system, we might literally have to exempt the justice system itself from the nation's primary data privacy law. Think about that for a second. Should courts get a complete free pass from the very data protection laws they are tasked with enforcing for the rest of us? It's this incredibly fascinating tension between our demand for fast, tech-driven efficiency and our fundamental right to privacy. I really hope this explainer helped you wrap your head around the complexities of this new legal frontier. Keep asking those tough questions, keep learning, and I'll catch you in the next explainer.